Welcome to Our Curious Amalgam, the weekly podcast brought to you by the Antitrust Law section of the American Bar Association. Our Curious Amalgam explores the fascinating and increasingly overlapping world of competition, consumer protection, data protection, and privacy law. Each week, we bring you leading global experts on the most compelling issues of the day. Enjoy the show.
Hello, and welcome to Our Curious Amalgam. I'm Alicia Downey, and the title of today's episode is What's Happening in France, Portugal, and Poland? The 2024 edition of the ABA Antitrust Law Section's spring meeting in Washington, D.C. offered the Our Curious Amalgam team a chance to speak with competition law regulators from around the world. We sat down with several of them to discuss their enforcement priorities and other issues, while also getting to know them a little better as people. First up in this special episode is Anora Wang's conversation with Benoît Cœuré, the president of the French Competition Authority. Next, you'll hear the interview that Jeny Maier did with the president of the Portuguese Competition Authority, Nuno Cunha Rodrigues. Finally, stay tuned to hear what's happening in Poland with Barry Nigro and Martyna Derszniak-Noirjean, the director of the International Cooperation Office of the Polish Office of Competition and Consumer Protection. Let's turn it over to Anora Wang.
In Europe, there are competition laws and enforcement both at the European Commission level and also at the member states level. Other than following what the EC does whenever we can, we would also embrace the opportunities to learn what some of the national competition authorities do. Today, I've got the privilege to speak with President Benoît Cœuré, who is an economist and since 2022 has been serving as the president of the French Competition Authority, which we will refer to as FCA, because you don't want to hear me say Autorité de la Concurrence one more time. Before joining the FCA, President Cœuré was head of the Innovation Hub of the Bank for International Settlements from 2019 to 2022 and chairman of the BIS Payments and Market Infrastructure Committee. He was also a member of the executive board of the European Central Bank from 2012 to 2019. And even before that, he had served in various positions at the French Treasury and the French Debt Management Office. Other than his career as a public official, President Cœuré is also a scholar who has authored articles and books on economic policy, the international monetary system, and the economics of European integration. Welcome to the OCA podcast, President Cœuré.
Thank you for having me today.
It's our pleasure. President Cœuré, so before we go to the several questions that we are interested in learning about FCA, can you give us a high-level introduction of your agency? Namely, what does it do in terms of enforcing the laws and also establishing independent regulation?
So, as you said, Anora, the European system is very closely integrated. So you have the European Commission at the center, and then you have 27 national competition authorities, of which the Autorité de la Concurrence is one. So what we do is antitrust enforcement, so cartels, abuse of dominance, as we call it in Europe, and so on. We do merger control, and we also have a very substantial advisory capacity, issuing opinions, market studies, market investigations, and so on. And we've been entrusted by the French government with regulating some legal professions, such as notaries, for instance, in France.
That's very interesting. So it's not just an enforcer, it's also a regulator. So what is your organization's top enforcement priority for the current year and maybe the next year?
So let me first say that we've been extremely busy last year in 2023 and again this year in 2024 on all fronts. Just to give you a few numbers to start from, in terms of opinions, we issued 20 opinions last year, which is double the number of the previous year. We took 266 merger decisions. A number of which with conditions, and we can come back to it later, structural conditions, behavioral conditions, and so on. And that's also an increase compared to the previous year. And we took 37 decisions in litigation, out of which 15 decisions on the merits, 10 decisions with fines, and 1 decision with interim measures. And we very much plan to keep up this very intense pace in 2024 with 3 priorities. First priority is digital. We've been very active historically and also very recently taking antitrust decisions against big platforms. Recently, we decided on interim measures against Meta in the ad tech sector. That was last year. Only a few weeks ago, that is in March 2024, we took a landmark decision against Google for not complying with the commitment they had taken with us on publishers' rights. That is remunerating press articles when they are being posted on the search engine. One dimension of it being not informing French publishers that their articles had been used to train the AI service, Bard, now called Gemini. This ended as a settlement with Google and including a 250 million euros fine against Google. We keep watching the digital sector very, very closely with a new development, which is the enforcement of the Digital Markets Act in Europe, and the French law giving us authority to implement the Digital Market Act and to support the Commission in doing so was voted only a few days ago in France. So that's the first priority, digital.
Wow. So that's a lot to unpack there, but maybe let's just go through the, maybe not every number, but you mentioned like 37 litigations in 2023, is that right? And are they mostly on digital, or are there other sectors that have been targeted or enforced against?
No, they span all. They span the whole of the French economy. So we digital is part of it. Infrastructures, like energy, transports are also part of it. And we've put a particular emphasis last year on consumer goods and groceries, given the inflation shock. And that's actually the second priority I wanted to mention, which is about supporting the living standards of French citizens and fighting against inflation. And so we had a number of decisions related to consumer goods also.
I'll have a follow-up to that. But talking about digitals for a second, so would cases or current cases are brought under laws of the French laws, but similar to the EC's, or?
So that's a very good question. It's actually European law. And so you might be surprised, but 90% of past decisions in Europe are based on European law. That is Article 101 and 102 of the EU Treaty. 90% of these decisions have been taken by national authorities. So it's a little bit like in the US, where state attorneys can take decisions based on federal law. So it's exactly the same. That's
the comparison I was trying to go there. So are there additional laws that you're enforcing other than the EC's law, Articles 101 and 102?
Yes, there are a few of them that are specific to the French legal environment. So, for instance, we have a concept of abuse of economic dependency, which is exploitative abuse, but with a specific French version of it that we can use and which you don't find in EU law. And also some articles of French law that you would be able to use in cases where there is no international trade or cross-border trade. Like, for instance, when we take decisions in French overseas territories, like French islands in the Caribbean or in the Indian Ocean, there are lots of competition issues there, unfortunately, because these are small communities, small territories. And whenever we intervene there, we use French law.
So maybe if we may get into your agency's litigation strategy for a little bit. So I certainly get that if that's only if the facts only concern a certain small islands or communities in French, it may not be like an EC case proper to be brought. But how do you strategize in terms of what case to brought when there are potential or ongoing litigation at the EC level?
So we need to strategize. because we're also a very small team. I mean, the total staff of my agency is 200 staff, which is not a lot to take so many decisions. So
including the merger handlers and
absolutely,
okay.
mergers, litigation, economic staff, and so on.
Okay.
So that's not a lot. So we need to prioritize. We actually have a new legally a new authority to decline cases if they are not a priority, which we've been using recently. So as a way to prioritize. And so what we do is that we also work closely with the French government, namely with the French Ministry of Economy, because they are in charge of consumer protection, which we don't do. And so whenever a case can be handled as a consumer protection case, then we just direct it to the French government so that they can take care of it. We really want to focus on antitrust and on cases that are legally important and where you need also some coordination at the European level. Because we are part of the European Competition Network, there is a lot of coordination going on with other national authorities and with the European Commission, and that's really our value added to be able to engineer this kind of assignment, finding the right assignment with the European Commission and with other countries.
That makes great sense. You did mention that you don't have the consumer protection authority or mission, but you also mentioned litigation or actions focusing on consumer goods was another focus of the past year, which was 2023. So how does that work? Because there was some debates around should competition laws be used as a tool to combat inflation? At least that was a debate valid here in the U.S. So what's your take on that?
I do think competition law can be useful to combat inflation. Of course, inflation is also a monetary discussion, and the European Central Bank in Europe would be at the center of it. But whenever we can fight conduct which leads to higher prices, we should, under our mandate, our remit. And that includes cartels, vertical cartels, horizontal cartels, which are very much at the center of what we do. And these are decisions which can have an actual impact on prices.
Now, why don't we move on to the next high-level question we have in front of us, which is, what is the most important trend that you're seeing, that you see that's developing in competition law enforcement in the near term?
Look, there are two answers here. The first answer is that we've seen digital cases becoming increasingly important. That's obviously an instance where we need strong European coordination, and we need to let the European Commission go ahead when they can, because we will be more effective as a team when the European Commission can lead it, which is why the Digital Markets Act is actually for the European Commission to implement. We can support it, but we are not at the center of it. And what we've seen here is that we see a shift from ex-post antitrust enforcement to ex-ante regulation as a way to make sure that gatekeepers, digital gatekeepers, big techs will behave from day one and will not wait until we investigate, do a dawn raid, and sanction them like 5 years later, or even 10 years later, or 15 years later, if you include the European Court of Justice and the litigation. And so this makes the whole system more efficient. That we have stronger ex-ante regulation. We see the DMA having a very material impact on decisions taken by Apple, by Google, by Meta. In terms of putting an end to self-preferencing, in terms of really changing the way they design their business. So that has been very effective. It is being very effective. But it also implies that we have to think very hard about the right way to articulate antitrust and regulation. Yeah. And so we just can't afford to see regulators are a different world. We need very, very close talks with regulators, including telecom regulators, energy regulators, transport regulators, and that's also a change of culture. Yeah. We need to be so. I know the U.S. government has this whole of government, approach, and it's probably not going to be called the same way in Europe, but we need exactly the same. We need to work as a team.
Right. And I just want to push back a little bit about regulation, especially within the digital space, because technology and everything is developing so fast. So the concern would be, would regulation be in a way preventing from innovation, or there are areas you just inevitably have to be catching up, right? So what's your take on that?
No, that's totally correct. And Europe has a reputation to be a heavy-handed regulator, and we have this Artificial Intelligence Act, so we are regulating industries which don't even exist yet. But it's also a way to provide clarity to the industry, because they know the environment in which they will operate. They don't have the Damocles sword of future regulation that would change the way they do business. So I think it's good to be clear about the way they will be regulated, but of course it has to be rather light-handed. And also, you need some proportionality in the way regulation addresses big firms as compared to smaller firms, because we know that very heavy and complex regulation can give an advantage to larger companies. And it has been said that GDPR, for instance, privacy regulation in Europe has been actually good for big techs, because it's so complicated that it helps them.
Just the cost of compliance would be
exactly
a differentiator.
And it kind of increases the barrier to entry in some industries, and even can help some gatekeepers to cement their dominance and their ecosystem. So we have to learn from that. And design regulation that is not a hindrance for the smaller players, because we want these innovative smaller players to be able to enter the market.
I think that makes great sense. Why don't we shift gear for a little bit? I think our listeners would be interesting to learn a little bit from you as a person. So what advice would you have for practitioners who want to be effective in front of your agency?
That's a very good question. I'm tempted to answer that the best way to be effective is not to violate competition law, so that they won't even be in front of my agency.
So that's a lost cause. If they're already in front of you, they're probably accused of doing something wrong.
No, I think we are always ready to listen to the arguments. And I'm the president, so I'm chairing the board. I'm not investigating. I'm chairing the board, so it's my duty to listen to what the investigation services have to say, but also to listen to the companies, and then to have a fair decision. So we're always ready to have a substantial discussion about the theory of harm, about the practices, about the evidence. My only advice would be, don't spend too much time and resources on litigating us on the procedures, because it's only going to waste time. And there is a lot of litigation going on from day one. When we do a dawn raid, the dawn raid is being litigated and appealed to the Court of Appeal in Paris, and then every decision related to business secrets is also being litigated, and so on and so forth. And so at some point you're 1 year, 2 years, 3 years after the dawn raid, and you haven't even started discussing the substance. I think I understand why lawyers are doing that, and it's absolutely their job to do that. But sometimes it's just a loss of time. So let's try to focus on the substance.
Yeah, not to have a down rate in the first place, maybe. So, do you have any interesting hobbies or accomplishments outside of competition law?
I come from the French Alps, so I do a lot of hiking, lots of hiking in the mountains. I enjoy really outdoor activities and skiing and hiking.
I see. So you have both in warm season and winter season, you get to enjoy the mountain.
Absolutely.
That's great. Thank you for being on Our Curious Amalgam.
Thank you.
Today, we are very lucky to have Mr. Nuno Rodrigues, the president of the Autoridade de Concorrencia in Portugal, speaking with us today, live from the spring meeting. Welcome.
Thank you, Melissa. It's a pleasure to be here.
Well, we are very fortunate to have you and all of the other enforcers here all together at the spring meeting, and looking forward to hearing from you about what are some recent developments in Portugal and things that we should be keeping an eye on as we look more broadly across the coming years. So perhaps maybe to just kick off our conversation, could you introduce yourself and tell us some recent initiatives that have been going on with your agency in Portugal?
Great. Once again, thank you for the invitation to be here. I'm Nuno Cunha Rodrigues, so I'm president of the Portuguese Competition Authority since March last year. And before that, I'm still a law professor at the Faculty of Law at the University of Lisbon, where I teach competition law, EU law, public procurement, among other stuff. So I already knew the team at the ADC in Portugal before coming to this position that I have nowadays, and really it's a brilliant team, and they are very excellent. So I'm proud of the team we have at ADC. ADC has been ranked as one of the 8 more relevant and prestigious competition authorities by GCR. And, we've been doing our work last year. I don't know if you want me to elaborate on the work that we've been doing.
Absolutely. What were some of the highlights that you'd like to share with us?
Well, last year we imposed a total amount of 35 million euros in 8 sanctioning decisions. We've been sanctioning cases such as bid rigging, the traditional bid rigging cases, very curious hub and spoke cases that we've had in the past. We had 13 decisions in hub and spoke, and this one was the last one last year, in a fine that was in the amount of 70 million euros. And then also in food supplements, and also very interesting, I suppose, here in the US in labor markets. We fined 2 companies in labor markets through settlement decisions in the total amount of 4 million euros. Also in merger control, we've been having a very intense activity. Last year, we cleared 82 merger operations in Portugal. There was 1 non-opposition with commitment decision, 2 phase 2 investigation decisions that were started and finished last year, and 9 gun jumping investigations that are ongoing. One of them was already closed, so we have 1 sanction decision for gun jumping. Also, when it comes to advocacy, we have 24 reports, opinions, and recommendations. I would just highlight 2. The first is about recommendations regarding the value chain of consumer goods. It's very based on the hub and spoke cases that we had in the past, and these are recommendations for companies to work in times of inflation, and what they should do, what they can do in this context. So this was a paper that was issued in April last year. You have the English version online available. And another issue paper I do think is very important is about competition and generative AI. This was issued in November last year. Many of the authorities in Europe, I know they are looking carefully for the Portuguese one when it comes to generative AI, and I'll be speaking here tomorrow in a panel about this. So it's about what issues, what competition risks are raised by generative AI, because I do think this is one of the next big things that will come in the future, and that we have competition forces to look carefully about, so that we don't waste our time, we don't lose time in order to look in advance for competition concerns that this new technology will pose.
Yes, I have a feeling that there will be a lot of discussion this week about generative AI and how it interplays with antitrust enforcement. But to just go back a minute, you mentioned that you had a case involving labor markets. That's certainly something that has been on the radar in the United States the last few years. Could you tell us a little bit more about the conduct that was at issue in the case in Portugal?
Yeah, sure. Those were no-poach agreements that were made between technological companies. We had already in the past, in the 2020, a case that was in sports activity of a no-poach agreement that involved soccer teams, popular, they're famous in Portugal, and there was a no-poach agreement between them due to the COVID-19 situation. And they were fined. The total amount of fines were around 11 million euros. And then the case went to the court, but the court is now on the verge to issue a decision, when we are hoping that the court will confirm the decision in terms of no poach. But we are also looking carefully to some situations that are investigations, so of course I cannot speak about them, but there are cases of wage fixing and again of no poach also, similar. And I do know that in the US you're also looking carefully now with the guidelines on merger control that expressly refer to the labor market. So it's something that we are looking carefully in Portugal. And again, we have ongoing cases and investigations in this context.
As you said just a moment ago, the sort of policy work or investigations and other related papers that your authority has written on generative AI. Are there any other sort of priority areas that the ADC is focused on in the coming year?
Yeah, let me go again to the no-poach situation, because we issued a paper in 2021 about no-poach, and we are doing an advocacy campaign through all the country about no-poach agreements in order to raise some awareness to the situation and also to understand if there are other cases that we can intervene about. So labor markets are, of course, in our first role in our concerns, but there are other areas that we are looking carefully. We are looking for the digital transition, and in Europe, I suppose you are aware the importance of the DMA has nowadays and how it interconnects with the enforcers and the competition enforcers. There are some decisions by the European Court of Justice in this context. There's one, the Meta case, that raises the importance of data and the comply with the GDPR in Europe, and the importance of having cooperation between competition enforcers and other sectoral regulators, such as data protection regulators. So we are looking for this cooperation in order to improve our work in this. Also, the importance of having innovative and advanced forensic IT tools. New IT tools, the use of AI, the use of web scraping, screenings, of course, in order to detect anti-competitive practices. So we are also working here in this field inside the ADC. Also looking for gun jumping situations, because in Portugal is one of the few countries in Europe, along with Spain, that the thresholds are also based on market share, so... and I do think it works. It's important nowadays because of all this stuff about killer acquisition, serial acquisition, export measure reviews, and the idea of having a market share has a threshold to the notification of merger operation. Although in the past was somehow criticized, I do think now it's more clear that it might work and it works in Portugal. So we have some situations here to detect in terms of cases of gun jumping. Also, another campaign that we are doing in terms of advocacy is going throughout all the cities in Portugal and explaining the importance of competition, in terms of not only advocacy, but raising awareness once again, but also trying to detect possible cases that happen all over the country. Many times when it comes to competition enforcers, we look to the competition cases in the capitals where we are based, where we have our headquarters. But we should also look to the rest of the country, such as, of course, in the US, in order to understand where these things happen, because they don't happen, of course, only in the capitals. So we are doing that in Portugal also. And also, once again, trying to strengthen our international cooperation also in the domain of digital markets, of the importance of the merger control regime in Europe, and of the famous Article 22 of the merger regulation, the famous Illumina Grail case, and that is still pending, but we are also looking for that and the cooperation that we have with the European Commission.
That's
so
great.
In a nutshell,
that's everything.
Yeah.
A lot going on.
Yeah.
Very interested to continue to watch. I will be making my first personal visit to Portugal this summer. And
let me know. Let me know. It will be a pleasure to have you at the ADC and
I would love
to have a coffee there with you.
Any recommendations on things that I must visit in Lisbon?
Oh, everything is wonderful in Portugal. It's not because I'm Portuguese, no, but really the weather is wonderful in Portugal. Maybe in August it's too much hot there, so. But you have to see all these monuments that you have in Portugal with 500s or 600s of history, like the castles, St. George Castle, the Jerónimo Monastery, the Belém Tower, from all the ships' departures in the 15th and the 16th century to the discovery's time. So you can also profit from the ocean, go to some beaches in Portugal, and profit from the food. The food is amazing, really, in Portugal. It's not because I'm Portuguese. So, and then you have all this kind of different landscapes all over Portugal. So you can go to the south. It's very different from the north of Portugal, and so taking like 3 or 4 days, you can get a flavor of different landscapes from snowing mountains to the oceans and wonderful beaches that we have in Portugal.
Well, that's fantastic. Now I'm even more excited to go than I already was. So other than being a fantastic travel guide to everything that you can see in Portugal, could you tell us something interesting or unique about yourself that we wouldn't know if we only knew you in your current role?
Not really. I suppose I'm a boring person, but and so I teach. I'm a law professor. I just teach once a week now. I don't have the time to teach more. I try also to publish some articles and books, and besides that, I try to hike, a little bit in the surrounding forests around Lisbon, and also you can visit them, Monsanto, so you can hike there. People do that, and I used to go there, and I try to go there during the weekend, also to bike a little bit, although Lisbon is a kind of a hilly city. So it's not easy to bike, but I have an electric bike, and so I try to use it to keep fit and also to profit from Lisbon, and that's it. Not different from the usual people.
Well, we really appreciate it, Nuno. Thank you for joining us. Really looking forward to visiting Portugal, and I thank you very much for sharing all of the current priorities and action going on in the ADC.
Thank you. It was a pleasure to be here. Looking forward to see you in Lisbon.
Yes, absolutely.
I'm Barry Nigro. With me today is our special guest, Martyna Derszniak-Noirjean. Martyna is the director of the International Cooperation Office within Poland's Office of Competition and Consumer Protection. She's responsible for international policy coordination and initiatives in the field of competition and consumer protection. Martyna is a public policy expert, having written and contributed to reports on a range of topics. Martyna, welcome to Our Curious Amalgam.
Welcome, thanks very much.
So let's start by learning more about Poland's Office of Competition and Consumer Protection. What does the agency do, and what are its recent major initiatives and accomplishments?
Thanks, and I'll start on congratulating you on pronouncing my name. That was quite good.
Oh, thank you.
And thanks so much for inviting us to this. Perhaps the best thing to say and start with is that WOKIC, our agency, has a quite broad range of competencies. So we are not only competition enforcers, we also enforce consumer protection laws. In addition to this, we are also responsible for trade inspection, supervising trade inspection and inspectorates in different regions of the country, inspection of safety of products and market surveillance. We are also responsible for enforcing unfair trade practices in the agricultural and agri-food sector. That's according to the UTP directive of the European Union. And we also work against combating payment gridlocks. So we have a very wide range of competencies, which also gives us a lot of powers and a lot of responsibilities. But competition enforcement is something we've started with. So our agency celebrated 30th anniversary about 3 years ago, and it was grounded as an anti-monopoly office, actually. So competition right now is our core, and it's about 30% of our budget as well. So it has a majority in terms of our focus. We are very happy also to say and to invest more in our enforcement and competition, and we have been growing our staff. We have been growing the number of people who are on board, the range of skills that they can bring on board. We have now about 170 staff in competition, and over 100 of them are lawyers. We have economists. We have also been working on acquiring data scientists. And we've been undertaking a lot of structural changes in order to streamline and focus and perhaps also make our work a little bit more efficient and effective. So that concerns our growth and our changes in structure and organization of the agency. We are also quite active on legislation level. So we advocate with the government, we advocate with the public, and we are quite involved with the legislative processes within the country. So we are also very involved as legislator and in the policy-making processes.
So it sounds like your agency touches a broad range of industries and within the Polish economy.
Yes, exactly. And actually, we are quite proud of having both the competition and consumer protection competencies. We see a lot of synergies in that. We see a lot of synergies in being able to address certain practices from either competition or consumer protection perspectives. And we also see a lot of benefit in being able to advocate with the public on certain issues. There is certain issues, for example, in digital markets or crisis-related areas where it's easier for us and more effective to advocate on the consumer protection level than on competition, which is of course relevant as well. But having both competencies is quite useful, and we are happy about this. But we also have a lot of other responsibilities.
If we look ahead, what are some of the current priorities of the agency?
In terms of priorities, we actually are trying to keep our eye on everything. So we are very alert to whatever is happening on the market, whatever practices are posing biggest threat to competition. And we are aware, of course, that we have limited resources. We cannot address every infringement. So we pick and choose those cases where we know we can send a strong market signal to the market participants. That's quite important to us. But in fact, we do address all kinds of issues. We have been involved with lots of classical things like RPM cases, and that pertains to all kinds of sectors in electronics or in motorization, but we've been also doing lots of novel kind of things. Like we had 2 cases in labor in a market in sports. Both decisions. One decision was issued last year. It was on Speedway and Speedway Federation and Motor and an extra league. And another one was on basketball, I think 2 years ago. So that we've been doing cases in digital market as well, but we've been also doing cases which are crisis related. So, for example, we, based on our UTP, unfair trade practices in agri-food sector competencies, we had several cases with very big fines on retailers in the last years, and we have also been doing cases. For example, we've issued a decision last year on a coal distributor for price fixing, which was actually an agency. They were trying to fix prices based on agency contract, which was not in reality an agency contract, and that was a result of our market study in the coal sector. Which was started due to the crisis and the high price of coal. So we've been we've been trying to cover all sectors, and we've been also very active on the policy level. We've been trying to expand our competencies and our understanding of the digital markets. We actually issued a very big fine. It's something about $45 million on our e-commerce platform in Poland. And that was for self-preferencing, as they were acting as a dual platform. And we also involved with digital markets on the policy level. We are active at the DMA as a high-level representative. Our president acts as the high-level representatives of the DMA, and we engage with market studies on that. So, of course, we are also active on the international level, trying to follow and discuss most important developments and try to exchange and try to build a common approach to those novel challenges.
That's quite a list of projects that you have going on. It's impressive for an agency your size. So what are your expectations with respect to future trends in competition law enforcement in Poland?
That's a good question. I think that the biggest driver of what's going to happen next will be the rise of and the emergent and the very dynamic nature of digital markets that really reshape every sector and the digital industry itself. That will pose many challenges, both in terms of gearing up as an agency in tools and in solutions that will help us investigate and counteract practices. And also, perhaps, I think that's already a trend that we see all over the globe and in Europe, that many agencies are trying to develop not only IT tools and organizational tools, but also new legal tools like ex-ante regulations like the DMA, Many countries are now also starting to think about new competences that would help them remedy certain issues on the market that they perceive on the market, which are not based on the classical competition law. So we are also looking into this, and perhaps this will also be solutions that we'll have to consider implementing. We'll be stay vigilant on the traditional markets that cover. We'll be still working with in the agricultural sector, because that's quite important for us. We see many problems on that sector, and we'll continue investigating them. So as much as we have to stay up to the newest developments and monitor the newer developments and stay in the game, we also have to monitor the traditional sectors. So that's one thing. We will also continue doing international cooperation, because we see a lot of benefit in exchanging, in sharing, but also that brings a huge benefit to harmonization of approaches, which gives a bigger impact of our actions individually and collectively as agencies all over the globe. And we will continue also trying to take a stronger exploit the synergies of our different competencies, and especially competition and consumer protection, because in the digital world you see that many infringement of consumer protection rights are actually also relating to competition infringements, and that can happen in any kind of other sector as well. And we will try to actually make this characteristic of our office an asset for us as well.
Yes, so there's not always a bright line separating competition and consumer protection. That's certainly something to be mindful of. So before we close, we like to learn something interesting about our guests. And I know that the only thing you like to think about is competition and consumer protection enforcement. But when you're not thinking about that, can you tell us about any hobbies or passions that you enjoy?
I can surprise you, actually.
Okay.
So it's not that I don't think about competition and consumer all the time. But in fact, one thing that is quite surprising is I'm neither a lawyer nor an economist. I'm a philosopher, so indeed I like to think a lot and about different kinds of things, and about competition and consumer protection from different kinds of perspectives. So that's quite interesting for me, and perhaps that's quite interesting for you as well.
It is. You're the first philosopher I've met practicing antitrust and consumer protection.
I wonder whether I'm the only philosopher here at the 4,000 people event. But
I bet you are.
Thank you.
Thank you.
Thank you for listening to this week's episode of Our Curious Amalgam, a competition, consumer protection, data protection, and privacy law podcast. It is produced and shared around the globe by ABA's Antitrust Law Section. The opinions expressed by the participants in this podcast are their own and do not necessarily represent their employer or other organizations. If you like what you heard or would like to become a member of the American Bar Association, please check out what the Antitrust section has to offer at ambar.org/antitrust. You can learn more about our podcast at ourcuriousamalgam.com. If you have comments, suggestions, or podcast ideas, please reach out to us at podcast@ourcuriousamalgam.com. Until next time, thank you for listening.